In this edition, I will be dealing with a topic which is the cause title part of the plaint? I really wonder how important this topic would be, except for some casual discussion over a cup of coffee at the association. I chose this as it is interesting academically and may come into use sometime or the other during our journeys as lawyers. In a second appeal before the Allahabad High Court, one of the points which came up for consideration was whether the notice for ejectment was invalid on the ground that though in the cause title the plaintiff had described himself as Karta of the family and adult son of his father, there was no averment in the plaint. There was not even the faintest suggestion that the plaintiff and his two brothers constituted a Hindu joint family. There was not even the faintest suggestion that he was Karta of that family, and also no averment that he was suing as manager of that family, and that the suit was on behalf of and for the benefit of the family. In fact, there was nothing there except the cause title, which said that he was the Karta. By reason of Order 7, Rule 4 of the Code of Civil Procedure, it was incumbent on the plaintiff to state in the plaint that he was suing as Karta, and the facts should have been stated supporting such an averment. In this case, the First Appellate Court held that the cause title of the suit should be treated as part of the plaint, and on that basis held that the notice of termination of tenancy issued as Karta was valid. This was negated in second appeal by the High Court. The cause title of the plaint can never be treated as part of the plaint, as it is not covered by the verification appended to every plaint at the end. Order 6, Rule 15 CPC provides for verification of pleadings. A reading of Sub-Rule 2 of Rule 15 would indicate that the person verifying should specify with reference to the numbered paragraphs of the pleading what he verifies as of his own knowledge, what he verifies as upon information received and believed to be true. Clearly, this does not cover the cause title. With the 2002 amendment and introduction of Sub-Rule 4 to Rule 15, there is a requirement that the person verifying the pleadings should also file an affidavit. It therefore follows that what is stated in the affidavit is only what is covered by the verification. As the verification does not cover the cause title, the affidavit too does not cover the cause title. In fact, if we go through the verification and we go through our affidavit filed, nowhere do we say that what is stated in the cause title is true and correct. This view seems to be bolstered by Rule 14 capital A of Order 6, which was inserted with effect from 1/2/1977, which requires a statement to be filed of the address of the parties. If the cause title had been covered by the verification and was part of the plaint, this provision may not have been necessary at all. It would therefore depend on the lawyer to make use of the discrepancy between the cause title, where facts may be sought to be introduced inconspicuously without making a corresponding statement in the plaint. This may appear to be a futile exercise, but in some cases where it's only the cause title which states a certain fact or a relationship or a status and there is no averment in the plaint, this topic would become important. There is a judgment of the Allahabad High Court in Mehbubullah versus Jwala Prasad Kajriwal, reported in AR 1974 Allahabad 413, where after discussing the facts, there is just a single line observation that the First Appellate Court erred in holding that the title of the suit was not part of the plaint. Though in the context of that judgment, this may not have been very important, but the fact remains is that such a view was taken. It can therefore be said fairly confidently that the cause title to the plaint does not form part of the plaint.